economic zone. Colombia relies on 11 affidavits to prove the existence of a long-standing practice of artisanal fishing by the inhabitants of the San Andres archipelago, in particular the Raizales. Having reviewed the affidavits on which Colombia relies, the court observes that they contain indications that some fishing activities have in the past taken place in certain areas that had once been part of the high seas, but that now fall within Nicaragua's exclusive economic zone. However, the court also notes that the affidavits do not establish with certainty the periods during which such activities took place, or whether there was in fact a constant practice of artisanal fishing spanning many decades or centuries, as claimed by Colombia. The court also notes in this regard that most of the affiants speak of having conducted their activities in waters surrounding the Colombian features, or identify fishing grounds located within Colombia's territorial sea, rather than Nicaraguan maritime areas. The court is mindful that traditional fishing practices alleged to have taken place over many decades may not have been documented in any formal or official record, which calls for some flexibility in considering the probative value of the affidavits submitted by Colombia. Nonetheless, the court is of the view that the affidavits submitted by Colombia do not sufficiently establish its claim that the inhabitants of the San Andres archipelago, in particular the Raizales, have been engaged in a long-standing practice of artisanal fishing in traditional fishing banks located in waters now falling within Nicaragua's exclusive economic zone. The court also considers that the positions taken by Colombia, inter alia, through its statements before the International Labor Organization Committee of Experts on the Application of Conventions and Recommendations, and through a 2004 resolution of Colombia's General Maritime Directorate, are inconsistent with Colombia's assertion concerning the existence of such a traditional practice of artisanal fishing in Nicaragua's exclusive economic zone. The court then turns to several statements of Nicaragua's head of state, which, according to Nicaragua, either illustrate Nicaragua's acceptance or recognition that the artisanal fishermen of the archipelago have the right to fish in Nicaragua's maritime zones without having to request prior authorization, or alternatively, create a legal obligation on the part of Nicaragua to respect those fishing rights. The court observes that in certain statements, President Ortega refers to the need to, I quote, respect the ancestral rights of the Raizales over those waters now fully belonging to his country, end of quote. In other statements by President Ortega, reference is made to the need for the Raizal community or the inhabitants of the archipelago to obtain fishing permits or authorizations from Nicaragua to carry on artisanal or industrial fishing. In addition, President Ortega made references to mechanisms that needed to be established between Nicaragua and Colombia before the artisanal fishermen could operate in waters falling in Nicaragua's exclusive economic zone by virtue of the 2012 judgment. In the court's view, the statement by President Ortega do not establish that Nicaragua has recognized that the inhabitants of the San Andres archipelago, in particular the Raizales, have the right to fish in Nicaragua's maritime zones without having to request prior authorization. The court next considers whether the statements of President Ortega constitute a legal undertaking granting rights to the artisanal fishermen. In determining whether a unilateral declaration by a state official entails the creation of legal obligations, the court recalls its jurisprudence that declarations made by way of unilateral acts concerning legal or factual situations may have the effect of creating legal obligations. The court has emphasized the need to consider the factual circumstances in which the unilateral statement was made and whether the state issuing the declaration intended to be bound by it. In this regard, the court is mindful that certain declarations may express a state's willingness to adopt a particular course of conduct without being expressed in terms of undertaking a legal obligation. In the Court's view, statements of Nicaragua's head of state indicate that Nicaraguan authorities were aware of the issues that arose in respect of the fishing activities of the inhabitants of the archipelago and the challenges that Colombia faced in implementing the 2012 judgment. The Court notes that in some of the statements adduced by the respondent, the Nicaraguan head of state expressed concerns regarding the rejection by Colombia of the delimitation effected by the Court and affirmed the need to work with Colombia on reaching an agreement to ensure compliance with the 2012 judgment. The Court further observes that both parties agree that the statements were made in the context of political protests in the aftermath of the 2012 judgment and against the backdrop of the ongoing negotiation with Colombia with the view of achieving an agreement on the implementation of the 2012 judgment. For these reasons, the Court concludes that Colombia has failed to establish that the inhabitants of the San Andres archipelago, in particular the Raizales, enjoy artisanal fishing rights in the waters now located in Nicaragua's exclusive economic zone, or that Nicaragua has, through the unilateral statements of its head of state, accepted or recognized their traditional fishing rights or legally undertaken to respect them. In view of this conclusion, the Court need not examine the parties' arguments with respect of whether or in what circumstances the traditional fishing rights of a particular community can survive the establishment of the exclusive economic zone of another state, or Colombia's contentions concerning Nicaragua's alleged infringement of the said rights through the conduct of its naval force. In light of all of the above considerations, the Court dismisses this counterclaim. Notwithstanding the above conclusion, the Court takes note of Nicaragua's willingness, as expressed through statements of its head of state, to negotiate with Colombia an agreement regarding access by members of the Raizales community to fisheries located within Nicaragua's exclusive economic zone. The Court considers that the most appropriate solution to address the concerns expressed by Colombia and its nationals in respect of access to fisheries located within Nicaragua's exclusive economic zone would be the negotiation of a bilateral agreement between the parties. The Court also emphasizes that under customary international law applicable to the exclusive economic zone, as reflected in Article 58 of UNCLOS, third states possess freedom of navigation in this area. It follows that the inhabitants of the archipelago, including the Raizales, may freely navigate within Nicaragua's exclusive economic zone, including in the course of their travel between the inhabited islands and the fishing areas located on Colombia's side of the maritime boundary. The Court now turns to Colombia's counterclaim relating to the alleged violation of Colombia's sovereign rights and maritime spaces through Nicaragua's use of strait baselines. On 27 August 2013, Nicaragua enacted Decree 33, through which it established a system of strait baselines along its Caribbean coast, from which the breadth of its territorial sea is measured. The decree identifies 9 base points. 2 are located on the low water line along Nicaragua's mainland coast, and the remaining 7 are located on the low water line along islands seaward of Nicaragua's mainland coast, and 8 strait baseline segments. Colombia raises 3 objections to Nicaragua's use of strait baselines. First, the respondent argues that Nicaragua has not met the necessary geographical preconditions required under Article 7 of UNCLOS, which reflects the customary international law on the use of strait baselines. Secondly, Colombia argues that even if those geographical preconditions were met, the manner in which Nicaragua drew those baselines contravenes the provisions of Article 7, Paragraph 3, since the baselines depart significantly from the general direction of Nicaragua's coast and enclose sea areas that are not sufficiently closely linked to the land domain to be subject to the regime of internal waters. Thirdly, Colombia argues that by employing strait baselines, Nicaragua is attempting to misappropriate significant maritime areas as its internal waters, and is artificially expanding its territorial sea, exclusive economic zone, and continental shelf in a manner that not only infringes upon Colombia's rights in maritime spaces, but also limits the rights of third states in the Caribbean Sea. For its part, Nicaragua asserts that its strait baselines were drawn in accordance with customary international law and the relevant provisions of UNCLOS, and that the applicant is therefore entitled to determine the status of the waters landward and seaward of those baselines in accordance with international law. The Court considers that Article 7 of UNCLOS reflects customary international law on the drawing of state baselines. Customary international law, as reflected in Article 7, Paragraph 1 of UNCLOS, permits a deviation from normal baselines where the coastline is deeply indented and cut into, or if there is a fringe of islands along the coast in its immediate vicinity. With respect to the strait baselines drawn from Cabo Gracias a Dios on the mainland to Great Corn Island along the coast, i.e. from point 1 to point 8, Nicaragua asserts that there is a fringe of islands along its coast in its immediate vicinity that entitles it to use strait rather than normal baselines. As to the southernmost part of its mainland coast, Nicaragua claims instead that the indentation of the coast from Monkey Point to the land boundary terminus with Costa Rica justifies Nicaragua's strait baselines drawn from point 8, Great Corn Island, to point 9, Barro Indio Maíz. The Court notes that there appears to be no single test for identifying a coastline that is deeply indented or cut into. Since Nicaragua concedes that it is only the southernmost portion of its Caribbean coast that falls to be considered under the second geographic option, the Court must determine whether the strait baseline segment between base points 8 and 9 is justified. An examination of the relevant maps reveals that Nicaragua's southernmost coast does in fact curve inward. Under the conditions reflected in Article 7, Paragraph 1 of UNCLOS, however, it is not sufficient for the coast to have a slight indentations or concavities. The coast must be deeply indented and cut into. The indentations along the relevant portion of Nicaragua's coast do not penetrate sufficiently inland or present characteristics sufficient for the Court to consider the said portion as deeply indented or cut into. Thus, the Court finds that the strait baseline segments between base points 8 and 9 does not conform with customary international law on the drawing of strait baselines as reflected in Article 7, Paragraph 1 of UNCLOS. The Court now turns to the remainder of Nicaragua's strait baselines running from point 1 to point 8. It recalls that base points used to construct strait baselines may be placed on islands, but they may not be placed on features that are below water at high tide, i.e. low tide elevations, except in certain circumstances which are not present in this case. In this regard, the Court notes that the parties are divided on the question whether Nicaragua's offshore islands constitute a fringe of islands along the coast in its immediate vicinity, within the meaning of Article 7, Paragraph 1 of UNCLOS. The Court notes that there are no specific rules regarding the minimum number of islands, though the phrase fringe of islands implies that there should not be too small a number of such islands relative to the length of the coast. Given the uncertainty about which of the 95 features listed by Nicaragua are islands, the Court is not satisfied, on the basis of the maps and figures submitted by the parties, that the number of Nicaragua's islands relative to the length of the coast is sufficient to constitute a fringe of islands along Nicaragua's coast. The maritime features shown on the maps may be divided into two groups on the basis of their geographic proximity. One group located in the northernmost part of Nicaragua's mainland coast, the second group located off the central part of Nicaragua's mainland coast. In determining whether the features identified by the applicant can be considered a fringe of islands, the Court observes that customary international law, as reflected in Article 7, Paragraph 1 of UNCLOS, requires this fringe to be located along the coast and in its immediate vicinity. Read together with the additional requirements of Article 7, Paragraph 3, according to which the drawing of strait baselines must not depart to any appreciable extent from the general direction of the coast, The specific requirements of Article 7, Paragraph 1 indicate that a fringe of islands must be sufficiently close to the mainland so as to warrant its consideration as the outer end or extremity of that coast. In the Court's view, a fringe must enclose a set or a cluster of islands which present an interconnected system with some consistency or continuity. Bearing in mind these considerations, the Court is of the opinion that the Nicaraguan islands are not sufficiently close to each other to form a coherent cluster along the coast and are not sufficiently linked to the land domain to be considered as the outer edge of the coast. The Court notes that Nicaragua's strait baselines enclose large maritime areas where no maritime feature entitled to a territorial sea has been shown to exist. The Court further notes that the features and islands located towards the south of Nicaragua's mainland coast appear to be significantly detached from the islands grouped in the north. Furthermore, the Court is not convinced that Nicaragua's islands guard part of the coast in such a way that they have a masking effect on a large portion of the mainland coast. In light of the above findings, the Court cannot accept Nicaragua's contention that there exists a continuous fringe of islands which guard this part of Nicaragua's coast. It follows that Nicaragua's strait baselines do not meet the requirements of customary international law reflected in Article 7, Paragraph 1 of UNCLOS. Having reached this conclusion, the Court need not consider whether the applicant's strait baselines meet the additional requirements reflected in Article 7, Paragraph 3 of UNCLOS. Nicaragua's own evidence establishes that the strait baselines convert into internal waters certain areas which otherwise would have been part of Nicaragua's territorial sea or exclusive economic zone, and convert into territorial sea certain areas which would have been part of Nicaragua's exclusive economic zone. The establishment of Nicaragua's strait baselines limits the rights that Colombian vessels would have had in those areas. The availability of the right of innocent passage in areas landward of strait baselines, consistent with Article 8, Paragraph 2 of UNCLOS, does not fully address the implications for Colombia of Nicaragua's strait baselines. The Court notes in particular that by converting certain areas of its exclusive economic zone into internal waters or into territorial sea, Nicaragua's strait baselines denied to Colombia the rights to which it is entitled in the exclusive economic zone, including the freedoms of navigation and overflight, and of the laying of submarine cables and pipelines, as provided under customary international law, as reflected in Article 58, Paragraph 1 of UNCLOS. For the reasons set out above, the Court concludes that the strait baselines established by Decree 33, as amended, do not conform with customary international law. The Court considers that a declaratory judgment to that effect is an appropriate remedy. For these reasons, the Court, by 10 votes to 5, finds that its jurisdiction, based on Article 31 of the Pact of Bogotá, to adjudicate upon the dispute regarding the alleged violations by the Republic of Colombia of the Republic of Nicaragua's rights in the maritime zones, which the Court declared in its 2012 judgment to appertain to the Republic of Nicaragua, covers the claims based on those events referred to by the Republic of Nicaragua that occurred after 27 November 2013, the date on which the Pact of Bogotá ceased to be in force for the Republic of Colombia. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Shui, Sebutinde, Bandari, Robinson, Salam, Iwasawa, Judge Ad hoc Dode. Against, Judges Abraham, Benuna, Yusuf, Nolte, Judge Ad hoc McCrae. 2, by 10 votes to 5, finds that by interfering with fishing and marine scientific research activities of Nicaraguan flagged or Nicaraguan licensed vessels and with the operations of Nicaraguan naval vessels in the Republic of Nicaragua's exclusive economic zone, and by purporting to enforce conservation measures in that zone, the Republic of Colombia has violated the Republic of Nicaragua's sovereign rights and jurisdiction in this maritime zone. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Shway, Sebutinde, Bandari, Robinson, Salam, Iwasawa, Judge ad hoc Dode. Against, Judges Abraham, Benuna, Yusuf, Nolte, Judge ad hoc McCrae. 3, by 9 votes to 6, finds that by authorizing fishing activities in the Republic of Nicaragua's exclusive economic zone, the Republic of Colombia has violated the Republic of Nicaragua's sovereign rights and jurisdiction in this maritime zone. In favor, President Donahue, Judges Tomka, Shway, Sebutinde, Bandari, Robinson, Salam, Iwasawa, Judge ad hoc Dode. Against, Vice President Gevorgian, Judges Abraham, Benuna, Yusuf, Nolte, Judge ad hoc McCrae. 4, by 9 votes to 6, finds that the Republic of Colombia must immediately cease the conduct referred to in paragraphs 2 and 3 above. In favor, President Donahue, Judges Tomka, Shway, Sebutinde, Bandari, Robinson, Salam, Iwasawa, Judge ad hoc Dode. Against, Vice President Gevorgian, Judges Abraham, Benuna, Yusuf, Nolte, Judge ad hoc McCrae. By 13 votes to 2, finds that the integral contiguous zone established by the Republic of Colombia by Presidential Decree 1946 of 9 September 2013, as amended by Decree 1119 of 17 June 2014, is not in conformity with customary international law, as set out in paragraphs 170 to 187 above. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Benuna, Yusuf, Shway, Sebutinde, Bandari, Robinson, Salam, Iwasawa, Nolte, Judge ad hoc Dode. Against, Judge Abraham, Judge ad hoc McCrae. By 12 votes to 3, finds that the Republic of Colombia must, by means of its own choosing, bring into conformity with customary international law the provisions of Presidential Decree 1946 of 9 September 2013, as amended by Decree 1119 of 17 June 2014, insofar as they relate to the maritime areas declared by the Court in its 2012 judgment to appertain to the Republic of Nicaragua. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Benuna, Shway, Sebutinde, Bandari, Robinson, Salam, Iwasawa, Nolte, Judge ad hoc Dode. Against, Judges Abraham, Yusuf, Judge ad hoc McCrae. By 12 votes to 3, finds that the Republic of Nicaragua's strait baselines established by Decree number 33-2013 of 19 August 2013, as amended by Decree number 17-2018 of 18 October 2018, are not in conformity with customary international law. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Yusuf, Sebutinde, Bandari, Robinson, Salam, Iwasawa, Nolte, Judge ad hoc Dode. Against, Judges Benuna, Shway, Judge ad hoc McCrae. By 14 votes to 1, rejects all other submissions made by the parties. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Sebutinde, Bandari, Robinson, Salam, Iwasawa, Nolte, Judge ad hoc Dode. Against, Judge ad hoc McCrae. I now call upon the Registrar to read the operative part of the judgment in French.
Par ces motifs, la Cour, 1. par 10 voix contre 5, dit que la compétence qu'elle a sur le fondement de l'article 31 du pacte de Bogota pour statuer sur le différend relatif à des allégations de violation par la République de Colombie des droits de la République du Nicaragua dans les espaces maritimes que la Cour a reconnus à cette dernière dans son arrêt de 2012, couvre les demandes fondées sur les événements mentionnés par la République du Nicaragua survenus après le 27 novembre 2013, date à laquelle le pacte de Bogota a cessé d'être en vigueur pour la République de Colombie. Pour Madame Donoghue, présidente, Monsieur Gevorgyan, vice-président, Monsieur Tomka, Mesdames Choué, Sebutinde, Messieurs Bandari, Robinson, Salam, Iwasawa, juge, Monsieur Daudet, juge ad hoc. Contre, Messieurs Abraham, Benouna, Youssouf, Nolte, juge, Monsieur McRae, juge ad hoc. 2. Par 10 voix contre 5, dit que, en entravant les activités de pêche et de recherche scientifique marine de navires battant pavillon nicaraguayen ou détenteurs d'un permis nicaraguayen et les opérations de navires de la marine nicaraguayenne dans la zone économique exclusive de la République du Nicaragua et en voulant faire appliquer des mesures de conservation dans cette zone, la République de Colombie a violé les droits souverains et la juridiction de la République du Nicaragua dans cette zone maritime. Pour Madame Donoghue, présidente, Monsieur Gevorgyan, vice-président, Monsieur Tomka, Mesdames Choué, Sebutinde, Messieurs Bandari, Robinson, Salam, Iwasawa, juge, Monsieur Daudet, juge ad hoc. Contre, Messieurs Abraham, Benouna, Youssouf, Nolte, juge, Monsieur McRae, juge ad hoc. 3. Par 9 voix contre 6, dit que, en autorisant des activités de pêche dans la zone économique exclusive de la République du Nicaragua, la République de Colombie a violé les droits souverains et la juridiction de la République du Nicaragua dans cette zone maritime. Pour Madame Donoghue, présidente, Monsieur Tomka, Mesdames Choué, Sebutinde, Messieurs Bandari, Robinson, Salam, Iwasawa, juge, Monsieur Daudet, juge ad hoc. Contre, Monsieur Gevorgyan, vice-président, Messieurs Abraham, Benouna, Youssouf, Nolte, juge, Monsieur McRae, juge ad hoc. 4. Par 9 voix contre 6, dit que la République de Colombie doit immédiatement cesser le comportement visé au point 2 et 3 ci-dessus. Pour Madame Donoghue, présidente, Monsieur Tomka, Mesdames Choué, Sebutinde, Messieurs Bandari, Robinson, Salam, Iwasawa, juge, Monsieur Daudet, juge ad hoc. Contre, Monsieur Gevorgyan, vice-président, Messieurs Abraham, Benouna, Youssouf, Nolte, juge, Monsieur McRae, juge ad hoc. 5. Par 13 voix contre 2, dit que la zone contiguë unique établie par la République de Colombie par le décret présidentiel 1946 du 9 septembre 2013, tel que modifié par le décret 1119 du 17 juin 2014, n'est pas conforme au droit international coutumier, ainsi qu'exposé au paragraphe 170 à 187 ci-dessus. Pour Madame Donoghue, présidente, Monsieur Gevorgyan, vice-président, Messieurs Tomka, Benouna, Youssouf, Mesdames Choué, Sebutinde, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, juge, Monsieur Daudet, juge ad hoc. Contre, Monsieur Abraham, juge, Monsieur McRae, juge ad hoc. 6. Par 12 voix contre 3, dit que la République de Colombie doit, par les moyens de son choix, mettre les dispositions du décret présidentiel 1946 du 9 septembre 2013, tel que modifié par le décret 1119 du 17 juin 2014, en conformité avec le droit international coutumier, en tant qu'elles ont trait aux espaces maritimes que la Cour a reconnus à la République du Nicaragua dans son arrêt de 2012. Pour Madame Donoghue, présidente, Monsieur Gevorgyan, vice-président, Messieurs Tomka, Benouna, Mesdames Choué, Sebutinde, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, juge, Monsieur Daudet, juge ad hoc. Contre, Messieurs Abraham Youssouf, juge, Monsieur McRae, juge ad hoc. 7. Par 12 voix contre 3, dit que les lignes de base droite de la République du Nicaragua, établies par le décret numéro 33-2013 du 19 août 2013, tel que modifié par le décret numéro 17-2018 du 10 octobre 2018, ne sont pas conformes au droit international coutumier. Pour Mme Donoghue, présidente, M. Gevorgyan, vice-président, M. Tomka, Abraham, Youssouf, Mme Sebutinde, M. Bandari, Robinson, Salam, Iwasawa, Nolte, juge, M. Daudet, juge ad hoc, contre M. Benouna, Mme Choué, juge, M. Macrae, juge ad hoc. 8. Par 14 voix contre 1, rejette le surplus des conclusions présentées par les parties pour Mme Donoghue, présidente, M. Gevorgyan, vice-président, M. Tomka, Abraham, Benouna, Youssouf, Mme Choué Sebutinde, M. Bandari, Robinson, Salam, Iwasawa, Nolte, juge, M. Daudet, juge ad hoc. Contre M. Macrae, juge ad hoc.
Vice President Gevorgyan appends a declaration to the judgment of the court. Judge Tomka appends a separate opinion to the judgment of the court. Judge Abraham appends a dissenting opinion to the judgment of the court. Judge Benouna appends a declaration to the judgment of the court. Judge Youssouf appends a separate opinion to the judgment of the court. Judge Choué appends a declaration to the judgment of the court. Judge Robinson appends a separate opinion to the judgment of the court. Judge Iwasawa appends a declaration to the judgment of the court. Judge Nolte appends a dissenting opinion to the judgment of the court. Judge ad hoc Macrae appends a dissenting opinion to the judgment of the court. The text of the judgment is available from today in TypeScript. It will also be available shortly on the court's website. The printed text will be available in the near future. As the court has no further business before it today, I declare the sitting closed.